Welcome. I'm attorney Peter Angelis. I'm a licensed attorney in the state of Michigan and also the state of Ohio. If you've seen any of my prior videos, you know that I try to offer content on best handling practices for serious personal injury claims, personal injury investigations, wrongful death actions, and complex insurance coverage cases. Most of my cases are in litigation, so I do a fair amount of trial work in the state of Michigan and also in the state of Ohio. If you like my content, please follow me. Please ring the bell and leave a comment down below. I'm told that helps out. I'm not sure exactly what it does, but it does help out. I've also decided to add a little incentive for you to leave a content message, little comment down below. First 20 people will get a nice Alexander Angelis Yeti mug. You'll have to call our office for some shipping instructions. So today's content, let's get to it. In Michigan, we have a saying, if you don't like the weather, stick around and it will change. Apparently, that holds true also for the practice of law. When I started practicing law, I guess it was 1988, we had premises liability, slip and fall claims, trip and fall claims. That would make up 15 or 20% of an attorney's practice. There was always an issue of, did you see what you tripped and fell over? In other words, was it open and obvious? But if it was open and obvious, the person back in the day when I first started practicing could still file a lawsuit if the condition was open and obvious, but the issue of open and obvious would go to that person's comparative negligence. And then about 20 years ago, through a Michigan Supreme Court decision, we adopted a standard that if the condition was open and obvious to an ordinary individual, that ordinary individual or that claimant is completely barred from suing the landowner or premises owner if he or she tripped or fell over something that was a defect on the property. So that's called the open and obvious defense. That's been that way for about 20 years or so. If the condition was open and obvious to a ordinary individual, you cannot make a claim for personal injury. There was a very famous case where a blind person, a person with sight impediment, tripped and fell over a defect in a restaurant. And because that defective condition was open and obvious to an ordinary person, certainly not to the blind plaintiff, that blind plaintiff was barred from making a claim. About 3 weeks ago, late July of 2023, the Michigan Supreme Court revisited the issue and made, again, a complete 360-degree circle from what the law was when I first started practicing in 1988, and basically tossed out the open and obvious defense. So now the open and obvious defense goes back to how it was in the old days when I first started practicing. If the condition was open and obvious, that person that's injured can still make a claim, but the trier of fact, whether that be the jury or the judge, is going to decide whether that open and obvious condition means that the plaintiff was at least 50% at fault for tripping or injuring himself or herself. If it was so obvious and the judge or the jury determines that, oh, you're 80% at fault, that case is still going to end up in a no cause for action, a zero verdict for the plaintiff. So this is what we're going to have to deal with. More cases are going to be going to the trial courts, the circuit courts. We're going to see a big flood of open and obvious issues that are going to be litigated, and we have to just basically deal with it. So what are some of the best practices that we can do? Well, if you're the premises owner or store owner, you know, that could be the general manager or store owner, the first thing obviously is to take care of the party that's injured at your premises. Make sure you call 911, get appropriate medical attention, make sure the person is secured and taken care of. Immediately after that, though, you should start an investigation as to whether there's any eyewitnesses. Many companies will develop a form, or they already have an investigation form, where they take note of all eyewitnesses, obtain their full name, full address, contact information, date of birth. If you can get a telephone number and an email number, that would be great. And then if they can handwrite a statement on their own and sign it, that would be great as well. Then take some photographs of the area. Never include the injured party in the photographs. Just take a photograph of the area as it appeared immediately after the incident took place. And then make sure that you store all this information in a very secure location. Follow your company procedures regarding storage of sensitive information. This information could be used and needed at least 3 years down the road. There's a 3-year statute of limitations to filing a personal injury claim. So I would keep this information that you develop at the scene of an accident, keep it for 4 or 5 years before destroying it. And you should have a written record destruction policy. If you're put on notice if there's a claim, you might have to keep the information even longer. So then, after the incident occurs, make sure you follow your company procedures. That could involve you handing over the claim to your insurance company. Your adjuster will contact you and obtain the information that we've just talked about. It'll be very helpful to your insurance company. And then once the insurance adjuster and the insurance company has the information, they should generally reach out to the injured party, try to get a recorded statement from the injured party, offer some assistance to the injured party. Most insurance policies have a medical copay provision. Doesn't matter who's at fault, but if the injured party has incurred some medical expenses and it's within your policy, insurance policy to pay, or even if it's not, it always creates some goodwill if you can offer to pay some medical expenses up front. So that's it. We're going back to the old standard. We're reverting back to 1988, where an open and obvious condition or defect on a property that causes an injury does not necessarily completely bar a personal injury case. It just means that we're going to have to investigate a little bit more to find out where the person was coming from, whether the person saw the object or defect or dangerous condition. Make sure that we've documented everything that happened carefully, photographs, witness statements, telephone numbers, and make sure we try to avoid even going into litigation by reaching out and offering some support to the injured party, see what we can do to avoid litigation. Again, Attorney Peter Angelis, my contact information will be at the end of the video. Thank you very much for tuning in.